In episode 11 of the Supreme Court Opinions Read podcast, I'll be reading the Supreme Court's opinion in Clark v. Sweeney. The case was decided November 24th, 2025. And there is no syllabus, so we'll move right on to the opinion, which was written per curiam. A Maryland jury found Jeremiah Sweeney guilty of second-degree murder and several other crimes. Sweeney's convictions were affirmed on appeal, and his bid for post-conviction relief in state court was unsuccessful. Sweeney sought habeas relief in federal district court, and that court too denied relief. But the Fourth Circuit reversed and ordered a new trial, relying on a claim that Sweeney never asserted. Because the Court of Appeals departed dramatically from the principle of party presentation, we reverse. Part 1. According to the state's witnesses at trial, Jeremiah Sweeney was arguing one night with neighbors about stolen marijuana. He eventually opened fire, missing his intended targets but killing a bystander who was about 75 yards away. At issue during trial was whether Sweeney could have been the shooter given his location and the angle of the bullet wound. After the state rested its case, Juror 4's curiosity got the best of him, and he decided to check out the crime scene for himself. Shortly after jury deliberations began, Juror 4 told the jury about his visit, and the jury promptly reported his visit to the court. The parties conferred and eventually agreed that rather than declare a mistrial, the court would dismiss Juror 4 and deliberations would proceed with 11 jurors. Sweeney was convicted, and his convictions were affirmed on direct appeal. Sweeney later filed a petition for post-conviction relief in state court. He argued, among other things, that his trial counsel was ineffective under Strickland v. Washington for not seeking to voir dire the entire jury to ensure that no other juror was tainted by Juror 4's unauthorized crime scene visit. The state court denied relief after a hearing. With the help of appointed counsel, Sweeney then petitioned for a writ of habeas corpus under 28 U.S.C. Section 2254 in federal district court. As in state court, Sweeney argued that his trial counsel was ineffective for not seeking to voir dire the entire jury. The district court denied Sweeney's petition, concluding that the state court's application of Strickland was not objectively unreasonable. In an unpublished opinion, the Fourth Circuit reversed, but not on the ineffective assistance claim that Sweeney brought. Instead, the Fourth Circuit declared that Sweeney's trial was marred by a combination of extraordinary failures from juror to judge to attorney that deprived Sweeney of his right to be confronted with the witnesses against him and his right to trial by an impartial jury. That error, the Court of Appeals concluded, entitled Sweeney to a new trial. Judge Quattlebaum dissented, criticizing the majority for flouting traditional principles of party presentation. Part 2. In our adversarial system of adjudication, we follow the principle of party presentation. The parties frame the issues for decision, while the court serves as a neutral arbiter of matters the parties present. To put it plainly, courts call balls and strikes, they don't get a turn to bat. The Fourth Circuit transgressed the party presentation principle by granting relief on a claim that Sweeney never asserted and that the state never had the chance to address. Sweeney asserted one and only one claim in his federal habeas petition, that his counsel was ineffective for failing to investigate whether other jurors had been prejudiced by Juror 4's crime scene visit. Instead of ruling on that claim, the Fourth Circuit devised a new one, based on a combination of extraordinary failures from juror to judge to attorney. The Fourth Circuit's radical transformation of Sweeney's simple ineffective assistance claim departed so drastically from the principle of party presentation as to constitute an abuse of discretion. We accordingly reverse the judgment of the Fourth Circuit and remand the case for further proceedings. On remand, the Fourth Circuit should analyze the ineffective assistance claim that Sweeney asserted. Under the Anti-Terrorism and Effective Death Penalty Act of 1996, relief is barred unless the state court's decision was contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States. When assessing a Strickland claim that a state court has already adjudicated, the analysis is doubly deferential. A federal court may grant relief only if every fair-minded jurist would agree that every reasonable lawyer would have made a different decision. The petition for certiorari is granted, the judgment of the Fourth Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. And that is it for the opinion in this case. Once again, a fairly short one and pretty straightforward one. Yeah, courts exist to settle cases and controversies. They don't exist to settle issues that are not brought before them. So if a party doesn't present some, issue to a court, the court generally doesn't get to decide that issue. And the only issue Sweeney brought before the courts was an ineffective assistance of counsel claim. Um, yeah, I don't know that there's really all that much to say about it. I mean, even looking at like what actually happened in this case, like it's not even all that concerning to me. Like, yeah, you had a juror that was tainted. That juror was struck, and then, maybe Sweeney's counsel should have, or it would have been prudent to have, um, voir dire the rest of the jury and see, okay, well, was the rest of the jury tainted? Do we need to strike any other jurors? Um, and then at a certain point, if you have to strike too many jurors, well, you don't have a constitutionally permissible jury anymore, and you're going to have to repanel a new jury for a new trial, and Sweeney's counsel didn't do that, and it, again, would have been prudent to do that, but is that ineffective assistance of counsel? Probably not. Ineffective assistance of counsel is a really, really, really high bar to meet. But yeah, I think that's honestly about all I have to say about this one. So, if I may ask you, my friends on the other side of the screen, please like, share, and comment. Follow the podcast wherever you follow podcasts, and if you'd like to support the show, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members have access to episodes early and any bonus or exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we will continue through the first opinions of the 2025 term. Spoiler, the next one is also going to be quite short. Until then.